Good morning, children. Welcome to the social session. Children, in the previous class, we were trying to understand about the background of making of Indian Constitution. Under that, we tried to understand the important features of the Indian Constitution, like the form of the government envisaged in the Indian Constitution, and what is the form of the Constitution itself. We tried to understand. Apart from that, the debates and criticism occurred in the Constituent Assembly when the draft Constitution was adopted by this Constituent Assembly or presented by B.R. Ambedkar. Also we have seen there was a large discussion on the fundamental rights, especially on the untouchability, and there was also a criticism by people like Damodar Seth as well as Maulana Hazrat Mohini. And we also have seen the definitions given to the untouchability by people like Rohini Kumar Chaudhary and Thakur also. Now, in the yesterday's class, we tried to understand about social engineering, how the society has to be built irrespective of the caste, irrespective of the property, irrespective of the religion, how the society has to be built. We try to understand it. And today, let us see about what is the constitutional or what is the position of the Constitution today in the present day. So when we look into that, the constitutional makers were aware of the laws will have to be amended from time to time because new challenges arises in the administration as well as in the country. In order to face them, the Constitution cannot be so rigid. So they had provided provisions even for the amendment. Amendment means changing in the sense you can add a new thing to the Constitution or you can remove the old thing from the Constitution. That is called as amendment. So this provision for the amendment, the procedure for the amendment is also mentioned in the Constitution. Thus it laid down the provisions for amending the laws and the articles of in the Constitution as well. Often laws can be made with approval of more than half of the members in the legislative houses. The laws can be made with the half of the majority in the houses. Generally, the government will have the majority in the house. Who forms the government, children? As you have already studied in class 7th and 8th, how to make the prime minister and how the chief minister is made. The majority in the house is considered as the leader of the house. So the government, in the sense, the one which possesses the majority in the house is called as government. That means when you have the majority in the house, more than half of the majority you have, then automatically you can make the laws. However, amending the articles in the Constitution can be initiated only by the Parliament but not by the state legislatures. Only the Parliament has the right to amend the Constitution, and that too, it also needs the approval of 2/3 of majority. 2/3. Okay. Out of 3 parts, 2 parts should agree for the amending of the Constitution. Making of the laws, if you have more than half of the 1/2, if you have more than that, that is enough to make the law. But to amend the Constitution, only Parliament has the power, and that too with 2/3 majority you can pass the law or amend the Constitution in both the houses of the Parliament. That means 2/3 of the majority in Lok Sabha and 2/3 of the majority in the Rajya Sabha. And some articles may be amended only with the acceptance or by the ratification also. Some articles, okay, not all, but some articles can be ratified with simple majority from the state legislature as well. It is further necessary that President of the country also approves the new amendment bill like other laws which has been passed by the Parliament. Without the President's signature or without the President's consent, the Constitution cannot be amended. Even though it is passed by 2/3 majority in Lok Sabha and Rajya Sabha, it requires the President's nod in the sense consent. Some major changes that took place in the Constitution during the 1970s. The first among them is the inclusion of 2 words to the preamble of the Indian Constitution. One is secular, the other one is socialist. These are the 2 important terms that have been added to the Indian Constitution during the 46th amendment made to the Constitution. So during this Constitution, these 2 words are very prominent. Secular mean irrespective of the religion. Okay, socialist mean the equality between the haves and have-nots, rich and the poor. So many words in the preamble like equality, liberty, justice emphasized the values of secularism as well as socialism, and hence these words were added to the preamble in the 1970s, that is in 1976. And the second major event of the Indian Constitution has been a judgment given by the Supreme Court during the Keshavananda Bharati case. So it was held that Parliament does not have the power to alter or to destroy the basic features of the Constitution. Even though Parliament can amend the Constitution, but it doesn't have the power to destroy the basic principles of the Constitution. This was a landmark judgment given by the Supreme Court in the Keshavananda Bharati case. That is most important case, children. So do not forget, it is a Keshavananda Bharati case. Keshavananda Bharati case. So during this case, the Supreme Court has upheld that the basic principles of the Indian Constitution cannot be changed. And the Supreme Court also has outlined what are the essential features of the Constitution which cannot be changed. In its judgment only it has mentioned. Some of the elements which have been mentioned by the Supreme Court as a basic structure are the supremacy of the Constitution. The Constitution is supreme. No other law in the country is as supreme as the Constitution. The sovereignty of the country, the supreme power of this country lies with its people only. That is the sovereignty of the country. You cannot change that also. The fundamental rights, the democratic form of the government, the secular character of the Constitution, the federal character of the Constitution, the mandate to build a welfare state. So these all are considered as a basic spirit of the Indian Constitution, which cannot be changed even by the Parliament. So presently, if you look, how many times the Indian Constitution has been amended in these 70 years. There is a graph given in the textbook, children. The Constitution of India has been amended during 1971-80 to 81-90. In these 2 decades, the Constitution has been amended more than 44 times. 22 times in a year. That means very rapid amendment of the Constitution has taken place during these 2 decades. That is the period of Indira Gandhi and Rajiv Gandhi, children. So during this period, the Constitution was amended very rapidly. And from 1950 to 2013, if you observe the graph, nearly 99 times the Constitution has been amended. Even recently also the Constitution has been amended in order to provide the 10% reservation for the EBC, economically backward classes. So even that was 105th amendment to the Constitution. So far 106 times the Constitution has been amended. What is the 106th is nothing but the exclusion of Article 370. Okay. So these are the number of times that Constitution has been amended, and we can amend the Constitution just with 2/3 majority in Lok Sabha and Rajya Sabha. So this is how the Constitution is present today, and presently the Constitution consists of 444 articles and 12 schedules, children. And you need to remember that the Constitution which has been prepared some 70 years ago, still we are following, and you have to respect the vision of these drafters of the Constitution. So in the next class, we shall understand about the next topic, children, but do not forget to complete the fair notes of this lesson, the making of the Indian Constitution. Thank you, children.